Hi, I'm John Strohmeyer, and today we're talking about directives to physicians, or living wills. These documents are used to make sure that a person can make their treatment wishes known before the need for care arises. So this document here in Texas, known as an Advanced Directive to Physicians and Family, also called a living will or an Advanced Directive, provides specific directions in two certain cases to doctors and family members on how care should be provided. This document usually works in conjunction with a medical power of attorney, because the medical power of attorney will grant somebody the right and the authority to make decisions for an incapacitated person, but the directive to physicians is going to act as a set of handcuffs on that medical agent. So the principal can use the medical power of attorney to authorize the agent to make decisions for them if they are incapacitated, and then hem in what decisions that agent can make using the advanced directive. Now, as the form comes from the state of Texas, we have two options we want to think about. First, what happens is you have a situation in which you're expected to die within 6 months. You can either have that life-sustaining treatment turned off, or you can have it kept on. The second situation is if you have an ongoing condition where you're also still incapacitated, but your doctors don't know when you're going to die. This is going to be a situation more like the Terry Schiavo situation from years ago, where they don't know when you're going to die, but they know that they've got a good idea that you're probably not coming back. So for both of those situations, the principal gets to make a decision about basically turning things off or leaving them on. Now, certain care options can't be removed, and they will still keep you alive. This form can't be used to authorize any sort of treatment that wouldn't be available to a person if they had capacity. So you can't authorize physician-assisted suicide or other treatments that that person couldn't get otherwise. Once they have that, then the agent is required to follow the instructions in that advanced directive. So they operate together. What we normally see with clients in our firm is that they'll always have that medical power of attorney document, but not every client wants to sign the directive to physicians. Well, why wouldn't they? The big reason to have this signed is you're making your wishes known. If your agent knows your wishes, then it's easier for them to carry them out. But if you're sure that your agent knows what decisions you'd want made, and you don't want to hem them in with these two broad situations that are provided by the state, then it's easier to say, I'm not going to sign this, and I'm going to trust my agent to make the right decisions for me. So the advanced directive is an important form, but we don't always see clients signing it. And ultimately, it comes down to, do you trust your agent to make the right decision? And it may be, I trust my agent, but I don't want them to have to make that decision for me. Ultimately, everybody will have to make their own decision on this form.